Good evening. I'm going to call to order the State of Rhode Island Coastal Resources Management Council's Rights of Way Subcommittee meeting to order. Today is Tuesday, July 22, 2025. I'm going to ask that the record reflect the subcommittee members that are present this evening, as well as staff members that are here. First matter on our agenda will be approval of the minutes from June 10, 2025 that have been disseminated. I would ask for a motion relative to those minutes, please. A motion has been made by Mr. Gagnon to approve. Is there a second?
Second.
Seconded by Ms. Reynolds. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? That they are accepted. Next matter is staff report.
There is no staff report tonight, Mr. Chair.
Okay. Skipping to number 4, Buttonwoods Rights of Way. Matters continued from April 8, 2025. I would turn it over to either Executive Director Willis or Attorney DeSisto at this point.
The question for tonight, and I believe there's a summary motion, a summary judgment motion that has been filed. Could the parties please come up? Thank you. Please do, yeah.
Stay a while.
Richard Lexeth, pro se. Attorney Christopher DeVideo for Buttonwood Beach Association.
And Mr. Langseth is the proponent tonight, and he has filed a motion for summary judgment. And while motions for summary judgment are not really appropriate in administrative matters such as this, I do think that since the parties are here and arguments have been interposed, that you should hear from them. Because to me, the real issue tonight is whether or not this matter, this right of way in the Buttonwoods part of Warwick should be sent out to a public hearing in the city of Warwick to get testimony from residents of that community and others on the matter. So that's the real issue tonight. The parties should argue, and then I'm going to have a recommendation for you after that. Mr. Langseth, because...
Just a clarification. So the evidence that has been presented thus far consists of a written record, which I think was established maybe back in April. Then we've submitted multiple filings, briefs, if you will, both parties. There'll be testimony or evidence presented this evening. Based on that culmination of that evidence, legal staff will prepare a report to the subcommittee as to whether or not adequate evidence, and I'm using that word adequate evidence because that comes out of your Citizens Guidebook, has been established to proceed to a public hearing or not. Is that accurate?
That is, of course, it depends on what the committee does, but that's accurate. I'm going to make some comments. But for purposes of proceeding now, there'll be no evidence tonight. This is time for argument.
And then just for that clarification, and that might be just a term of art, adequate evidence may be used in the Citizens Guidebook for the average person. But adequate evidence, is that similar to substantial evidence, which is typically what an administrative body uses as a threshold for making its findings?
The more appropriate word is sufficient.
Okay, so I just don't know that word sufficient evidence in the context of administrative proceedings. Typically, it's substantial evidence. So we're not talking about substantial evidence, we're talking about the sufficient evidence.
You're jumping ahead. Okay. Because there isn't, as you might know the process, I don't know. I know Mr. Langseth does. The record won't be complete. The record is never complete for any right of way until the public's had a chance to speak in the host community. So that's why I'm using the term sufficient. The question tonight is whether or not there's enough in the record to get to that point. That's why I'm not using that term.
Very well.
And you know me, I don't like to argue over language. Mr. Lang said, please proceed.
So I have a opening statement that I wrote down and I'd like to read it. Might take 10 minutes.
Well, Mr. Langseth, here's the thing. Did you please do the opening statement,
Okay.
but you should go right into your arguments too.
Oh, I'm sure you, I will. Number one key consideration for the subcommittee to review is the Buttonwood Beach Association's duty under the Buttonwoods deed stipulations to file plat maps in the land evidence, open the streets to the public, and market the lots to the public to repay the mortgage. The stipulations roll into a manifest, which is obvious intent by the BBA to dedicate the streets to the public. Hey, would you like a copy?
What you're reading?
Yeah.
No, I'm just taking notes. Thank you, though.
Okay. Number two, the BBA's plat map of 1882 was a replatting, as noted by the surveyor in the plat map. As a successor in interest to the trustees, the BBA, through the surveyor, rededicated the streets, ways, and commons to the public. This is an incipient dedication with manifest intent to preserve the integrity of the mortgage financing through the deed stipulations. And I cite Chaplin v. Brown, which cites Bartlett v. Banger, which is a case in Maine, which was the first incipient dedication case that can be found in the record. Number three, the trustees' compliance with the deed stipulations is at least substantial, manifest, obvious evidence that the trustees willingly made an incipient dedication with the BBA following along as a successor in interest. And I cite Chapin. Number four, it is important to note that the BBA is not named in deeds transferring the Buttonwoods purchase to it. It relies on the trustees' deeds and must comply with the trustees' deed stipulations. The trustees' deeds are the BBA's responsibility. In other words, if you go to the land evidence, you won't find any deeds to the BBA. They're to the trustees, and then the trustees cede over the deeds to the BBA. Direct acceptance by the public. Acceptance of the emerging incipient dedication of the Buttonwood streets first emerges as a direct public acceptance. Because the BBA built a public hotel across the street from its train station and post office, public use emerged for the people to get from the station to the hotel. The post office was a public facility for those walking in from Oakland Beach and the Budlong Farm, a public use of the streets. See Chapin v. Brown, where Rhode Island Court cites Bartlett v. Bangor with its references to the incipient dedication and acceptance by competent authority or the public, with the public directly accepting the dedication if, in quotes, the public has used them, the streets, for at least 20 years, unquote. Number six, following Simmons v. Cornell, the Rhode Island statutes of 1715 and 1767 make provision for direct public acceptance. Once a proprietor dedicates a street to the public, which the trustees did in 1871, and the BBA replatted in 1882, the streets and the plats are, by necessity, accepted by public when the public uses the streets for 20 years. Number seven, the renowned surveyor N.B. Schubarth in his 1882 replat of Buttonwoods filed in the land evidence expanded and enhanced his 1871 incipient dedication. He drew in the BBA's hotel across the street from the train station and post office. Mr. Schubarth drew into the 1882 replat a street reservation at Hemlock Avenue, demonstrating his knowledge of the craft of surveying and platting in relation to the deed stipulations requiring the platting and opening of streets to the public. In other words, he knew what he was doing. I cite Newport Realty at 1035. Number nine, the public nature of the streets at Buttonwoods is spelled out in Supreme Court's findings in Clark v. Buttonwoods. In its opinion of this Buttonwoods matter, at page 693, the Clark Court spoke of the trial judge's findings, and I quote, "The trial justice did not misconceive or misconstrue the evidence introduced during the trial. At the trial, Justice noted in his decision, the deed to 243 Promenade Avenue refers to the 1882 plat. The 80-foot public width represented on the 1882 plat is undisputed. In other words, that's what the Supreme Court found. Number 10, plats are a unity. Streets are a public character. In Providence Steam Engine versus Providence and Stonington Steamship Company, the Supreme Court found all owners of lots on the plat might well be held to be stopped from denying it to be a highway. Number 11, in its memorandum of law in opposition to my petition at page 16, the BBA acknowledged the public findings of the Supreme Court, quoting, the Rhode Island Supreme Court in Clark v. Buttonwoods at 685 found the BBA streets to be public. Now that point is contested by Mr.
Video.
Just think
of video.
No video, okay.
Thank you.
Anyway, he protests that point, but that is in the record. The Clark Court details the findings of the expert surveyor testifying at the trial at page 693 in the appeal. Quote, this 80-foot public width included the concrete sidewalk on the waterfront lot. The survey showed that the 80-foot public width extended before the concrete patio. That's the expert witness in the trial, Buttonwoods v. Clark, which both parties agreed that he was an expert and he found it to be a public road. Number 13, the Clark Court includes the expert surveyor's survey as attachment A, in quotes, to provide a visual reference for the property features, unquotes, as noted in footnote 3 at page 693 of the Supreme Court decision. So if you go to the Supreme Court decision and you look at attachment A, which they included, it will show Promenade Avenue as a public highway, Supreme Court. Now we're going to talk about the abandonment of F Avenue, a public highway. Number 14, in 1976, the BBA petitioned the Warwick City Council for it, the City Council, to abandon F Avenue, a street that the BBA dedicated to the public in 1882, as I described earlier on. For the Warwick City Council to abandon the street, it needs to be a public highway or driftway. Under Rhode Island General Laws 2461, notice this statute establishes, quote, whenever by the judgment of a town council of any town, a highway or driftway in the town or any part of it either has ceased to be useful to the public, the town council then is authorized to declare it by order or decree shall be final and conclusive, and thereupon the title of the land upon which the highway or driftway or part thereof shall revert to its owner. Okay. Number 16, as the city council records show, it docketed its action on the BBA petition as ordinance 07623. It followed the RI General Laws 2462, notice of abutting landowners of a proposed abandonment, letting them know that the former street would be merged into their properties to the center of the street, that being 15 feet, which requires, and I can quote, every town council before proceeding to abandon any highway or driftway or any part thereof shall give notice to the owners of the lands abutting upon any part of the highway or driftway. Personal notice shall be served to every person known to reside within the state who is an owner of land abutting upon that part of the highway or driftway which it proposes to abandon. So clearly, the BBA petitioned the city to abandon a public highway. Then the city put it into the docket, and then as 17, the city council records show that it acted on the BBA's petition to abandon F Avenue under 2461. 18, the city assessor assigned the underlying property to the abutters, as now shown in the GIS mapping system. Each half of the former F Avenue was assigned to the abutters. Since that time, the abutters have obtained taxes on the former F Avenue street bed. Number 19, a building permit for a home on an abutting property received by the Warwick Building Department on May 12th, 2014 shows 15 feet, half of the former F Avenue highway abandoned and merged into the assessor's plat 374 lot 36 where the home was built. This building permit was approved by the city and the house was built. Number 20, in the summer of 2019, the BBA was presenting its case against my petition for the recognition of rights of way at Buttonwoods. It was at this time that the BBA chose to revisit F Avenue abandonment and claim ownership of this abandoned public highway. An easement was filed by the BBA in the land evidence at book 9364, page 20 to 25. The agreement included, whereas the BBA has real property interest in F Avenue, a platted street. Whereas the city of Warwick's interest in F Avenue shown on the plat was abandoned by resolution, actually ordinance, of the Warwick City Council, and from this abandonment, the abutter obtained an ownership interest in the center line of F Avenue. No, the abutter didn't get an ownership interest, the abutter got the avenue. Whereas improvements from the BBA's land have been constructed within the boundaries of F Avenue, that statement's false. Number 21. The Buttonwoods Fire District was called into the easement as filed on page 25, recognizing, and I quote, this is what the Buttonwoods Fire District agreed to, the abutters' rights under the easement agreement, the BFD will conform its road maintenance and repair activities in F Avenue and exercises other powers regarding such platted streets in a way that it will not impair the abutters' rights under the easement agreement. Number 22. This recognition agreement was signed by the senior supervisor of the BFD on September 29th, 2019. It is a recognition of the fire district's commitment to maintain the streets of Buttonwoods for the public, a public acceptance. And I cite Warwick Sewer Authority versus Cologne. 23. Now, in its June 17th, 2025, Sir reply, the BBA describes the 1976 City Council legislative action to abandon F Avenue as an anomalous outlier. The implication is that the abandonment was a mistake of some kind. Number 24. The Supreme Court in Noyes versus Partially, citing Godina versus Gobeil, that of the legislative action in the Godina case, a street abandonment is not reviewable. The writ is confined to a review of errors of laws, a particular error of law appearing in the record of a judicial or quasi-judicial proceeding. Number 25. In its review of the BBA petition to the City Council for it to find the streets of Buttonwoods to be public, the subcommittee can note that the City Council's legislative action to find the streets of Buttonwoods to be public, but cannot adjudicate the question on the separation of powers, citing Godina. 26. In Morgan versus Railroad Company, the U.S. Supreme Court cites City of Cincinnati versus Lacey of White, 6 Pete 431. Here the owner's acts and declarations regarding his dedications of train stations to the public operated in the nature of an estoppel and pass precluded the owner from revoking the dedication. 27. The same is true at Buttonwoods with the BBA's train station and the U.S. Post Office on the public highway approaching the Buttonwoods Hotel as shown on the plat map of 1882. As agreed to by the BBA in its memorandum of law, such use of the highway by public becomes a public acceptance of the street. And I cite Morgan. Number 28. The BBA is stopped from claiming that its 1882 petition of Buttonwoods Avenue to the public is now invalid. It being accepted directly by the public, number 1, recognized by the city of Warwick, number 2, and the Buttonwoods Fire District as public. 29, and finally, an incipient dedication can only be revoked by consent of all property owners in the plat. The BBA has not presented that revocation petition, nor is it expected, and I cite Newport Realty at 1041. Conclusion. For these reasons, I respectfully ask that the subcommittee find the BBA dedicated the streets and parks at Buttonwoods now public, clearing any controversy in answer to my motion for summary judgment. The public has accepted the BBA's incipient dedication through a history of long-term use reaching back to the BBA's 1882 dedication. This stops any attempt for the BBA to roll back or revoke the incipient dedication. It has accepted. The city of Warwick recognized the streets of Buttonwoods to be highways in 1976, and the Buttonwoods Fire District also recognized these streets as public in 2019. These recognitions are further substantial evidence of an acceptance. The subcommittee should then direct staff to prepare for a public hearing on this matter.
Thank you. Anybody on the subcommittee have questions for Mr. Langseth?
Any questions? No?
Thank you. Mr. DeVideo?
Yeah, so there's a lot to cover here, but the arguments presented in the record reflects that the petition, this right of way, is based on a public road exists. Now, our jurisprudence in the state is very well developed on how a public road is established. First, you need a dedication. Second, you need an acceptance. Now, that acceptance, first, I'll get the dedication and acceptance. I think that the acceptance component is most important. The acceptance requires an official act by the town or the city to accept the road as public. Mere public use is insufficient. You can have either an official act, or you can have public use, which is broad over a long period of time and adverse and as a matter of right, meaning not permissive public use. It's adverse to the owners of the property as if you're using that property as a matter of right. Then, of course, the city of Warwick, in this case, well, actually, it could have been the town, because at that time it was the town, way back before, I don't know, 1936 or so. The municipality would have had to take an official action. Now, that two-step process, dedication and acceptance, and of course, there's a two-step process within acceptance, never happened. The relevant statutes on that and the case law, which is cited in my briefing, which speaks to that two-step process, is 24-2-1 and 24-2-4. Now, the petitioner argues that BFD is somehow this, because it is a quasi-public entity, and when it was established in 1925, it accepted these roads as public roads. Because when the plat map was presented to the General Assembly, of course, they presented the map to show what their taxing jurisdiction area was. Wasn't in the presentation of the map wasn't an intent to dedicate. And the BFD, frankly, more importantly, as a matter of law, as defined under the statute, does not have the jurisdictional authority to accept a public road. That's beyond their authority. And there are cases where East Greenwich Fire District did have very broad legislative powers. That's absent here. So we don't have acceptance. And with respect to so much which was said here, I have not seen in the record this deed stipulation. I have not seen this mortgage in the record, which goes to Mr. DeSisto. As I understand the legal standards in administrative proceedings, is that you need legally competent, probative, and reliable evidence. Now, I understand that the CRMC has somewhat of a loose process about accepting evidence, but I don't have the deed, neither do you. I don't have this mortgage. Now, let's get to this concept that there's a train station and a post office and a hotel. I don't see anything on the plat about a post office. The only assertion there's a post office has been in his statement. I've searched the record for office, post office. I may find it in a one-liner, there's a post office there, and he's saying it. But even if there was a post office, which there needs to be reliable evidence in the record that there was a post office. I had rented office space, CIC building. I'm a tenant. Get in, I need a little key pass on my wrist to get by all the doors. Inside there's a United States postal box. That's for the convenience of the tenants, not for the general public. So I don't know to the extent this post office, who it was used for. He says people walk there, so on and so on. Doesn't mean it was adverse or hostile to BBA. Could have very well been set there for the purposes of convenience, like my post office is in my office, but it's not there for the general public. Or even if it was there for the general public, people weren't using that post office and traversing on BBA's property in an adverse as of right manner. With respect to the hotel, been to a resort before, an all-inclusive resort. It's not open to the public. That hotel and the people going to that hotel are there in a permissive manner. You need to make a reservation, and that's how they're able to get on to this hotel. So I don't think there was broad public use, adverse, as of right against this property. And we know there has not been an official action by the city of Warwick or the town of Warwick to accept these as public roads. The case law is very clear. Now, with respect to this F Street, again, I don't see any evidence in the record for me or you to be able to look at. Maybe there is. And so far that is an anomaly. Let's look at all the evidence that's in the record. By the entity, who would be authorized to accept these as public roads? Well, we've got the city solicitor saying these are private roads. Maybe there was an incipient dedication, but these are private roads. We have an ordinance by the city of Warwick recognizing them as private. We've got the Rhode Island Attorney General's opinion that these roads are private. And lastly, let's not forget Clark v. Buttonwoods, the case that that the petitioner is citing as these are public. Well, first of all, whether he wants to cite to something that was cited in our case, and you will see it in my reply. I think it's going to be misinterpreted and misapplied. Put that aside, it's a scrivener's error. How about that? And I specifically state in my brief that is not the position of EBA, and it never has been, and it never will be, that these roads are public. In fact, what Clark actually says, this is the Supreme Court. We don't make a determination as to whether these roads are public. The trial court didn't, and neither do we. However, they do state, that is the Supreme Court, in their decision, that this is established as a summer resort, that these roads are private. So Clark actually reinforces our position. And by the way, the Clark case was on Promenade Ave. One singular street and an adverse possession claim. But there is a declaration from the court that these streets are private, owned by the BBA. So if you want to look to Clark for anything, that's what it stands for. You'll see it in my briefs, particularly my last, maybe either the SIR reply or the SIR. So insofar as this acceptance and broad public use, either there's insufficient evidence in the record to support any of the assertions, because I can't see them. They're not in the record for me to review. And I think the evidence demonstrates that these are private by authoritative bodies, particularly the city of Warwick. Now, let's look at this dedication. The case law is very clear. This is in the Rabideau v. Pelletier case, 391 A second, 1150. We're essentially saying is that dedication of a private property to the public is an exceptional, unusual method. There must be either words or conduct that reasonably tend to demonstrate such an intention. So let's look at the intention. In 1882, they file this, they get a charter to create a company to sell lots. And they record the rest, that is, plat map, to show what they're going to be selling stock in. Okay. Now, as this Clark court said, and which says this was established as a summer resort. So let me ask you, again, when you go to a resort someplace, I don't know, wherever, and the warm waters, okay, these are confined places. You don't set up a resort with the intent to make it not exclusive or to be private. And in fact, that is the whole point of and I would argue that if you set it up as a resort, hey, come folks to this nice private place on Greenwich Bay. It's a resort. It's a hotel. The hotel, notably, as tradition had it, was a way for people to go stay at the hotel and say, geez, that's a nice little private community. I'd like to buy a lot there. As far as the railroad station, again, permissive, great. You want to put a railroad into my property to bring people down to our resort, that's fine. There's no evidence that that railroad used eminent domain to put that railroad in. It wasn't adverse to BBA. And as I said, in the Rabbit case, the Rhode law presumes against dedication. There's no dedicatory language in any of the plat maps. I think that when we look at the intent and that they were intended to be private and not dedicated, comes from the formation of the summer resort. And more importantly, why would the BBA seek the General Assembly Act creating Buttonwoods Fire District? If the roads were public, then the city or town at that time would have been the ones responsible for maintenance, both actual work and the cost. But instead, they weren't. In fact, that's what the BFD was created for, as a taxing authority to collect taxes to maintain these private roads. Again, indicative of the intent to not dedicate, indicative that an acceptance had not occurred. We have an easement with the Warwick Sewer Authority. They want to put sewer lines on BBA property. If they were public roads, you don't need an easement. All these facts that point to these are private roads, were never intended to be public, they've never been determined to be public. The petitioner is looking at old maps, legislative acts, a whole host of things to assume and interpret that a dedication and acceptance occurred. If they're not public roads, they can't be a public right of way, because that is his core argument by the petitioner, is that because they're public roads to acceptance, a dedication acceptance, therefore the public has a right to pass over them to a tidal shore, to the shore. Now, insofar as Comstock, Andrew Comstock Road, I believe it is, the end of that road is a private house, not part of BBA. I don't know how you get to the shore there anyhow. In fact, I've been there. It's very steep and wetland kind of thing. So how Andrew Comstock comes into that light. Buttonwoods Ave does go to the tidal shore. Sure, we agree with that. So doesn't Promenade, though it's on a peninsula. The entire Buttonwoods estate is on a peninsula. So anything that touches that is on tidal waters. The only affidavit of public use of the road, for example, particularly in the park at the end of Buttonwoods Ave, is an affidavit of the petitioner, Mr. Richard Langsett. While he was a tenant there, he says in his affidavit, I regularly went down there, raked up the park, burnt the woods, so forth and so on. That was permissive use. He was a tenant there. It wasn't the general public coming in and using it adverse as of right. As far as I can tell from his affidavit, he was a resident there. And that was his right to, as any other tenant or homeowner, to use these roads because he had a legal interest. Now, I think that actually covers most of it. Let me just check to see, because there was a litany of things that were asserted here. Not familiar with, by the way, this is a Ocean Street reservation, the plat map, looked at it. Avenue. There was an error of law, a quasi-judicial, you can't review it. Well, that abandonment, whatever, how it occurred, would have been through the town council. That's a legislative act, so, which is part of the problem here. And I recognize that the petition is pro se. But there needs to be a fundamental understanding of law. Just throwing out legal parameters in a quasi-judicial context when it should be applying to a legislative act is not reliable, it's not probative. I would say it's not legally competent. I know that your rules of procedure allow a pro se litigant to appear, but that pro se litigant is held to the same standards as an attorney, myself. So when I make an assertion, it's from the record when I cite a something legally, a doctrine or otherwise, I make sure I research the case and that there's a match between the facts alleged or the evidence there and the law. I don't bring in, for example, case law from a different state, which has a different standard determining public roads or public rights of way. The nexus doesn't exist. And what that has done is it's frankly caused a client, for me, spend a lot of time having to rebut legal arguments that are just not sound. And so this just maybe just a level of frustration. I know my clients are here and they're very frustrated with the process. So we have to go over that nonetheless. I know one of the arguments is made that, that this CRMC is stopped from examining the legislative intent. It's called the 1882 Charter, the 1925 creation of the BFD and any amendments that are annexing thereafter. I don't think you need to look at the legislative intent. I think you just look at what the statute says or the act says. You need to go beyond that to look at that. So I reserve my time for any rebuttal.
Well, I'm gonna make a suggestion here. Okay. Excellent job by both sides on this. And as they both alluded to the fact that we've got quite a bit of information that has been disseminated to the subcommittee on this issue. So what I'm gonna recommend is that based on these reports, and we gotta get the transcript from it, that Mark and I will prepare a report to the committee. We'll circulate it to the parties ahead of time, along with a recommendation as to whether or not this particular right of way proceeds to the next step, which would be a public hearing in the city of Warwick. And I think that's about the only way to handle this, because we do have a lot of information here, and I think it has to be summarized and taken forward in that fashion.
One comment, it was a personal attack against me, so I think it's appropriate to comment on the personal attack. It was suggested that I'm not competent as a lawyer. I'm not a member of the Bar Association. I am not a lawyer, but I do feel that I'm competent in the law. And he suggested that I used an out-of-state case. I did not use the out-of-state case. Exactly what I said was Chapin v. Brown, 10A 641 640 of RI 8 in 1887 cited Bartlett versus Bangor. I did not directly cite an out-of-state case. I cited the Rhode Island case, which referred to the out-of-state case. I just wanted to let everybody know that I feel that I should respond to that.
Yeah, I would
Thank you.
just suggest, just read all that has been submitted by Mr. Langseth in the context of all the briefing. And there are cases from Maine, Massachusetts, all over, not just cited by a Rhode Island case. They're directly a legal assertion followed by a case from Massachusetts. I think it's Onset or another case. So
You guys, you don't have to continue on with this.
thank you.
You don't have to continue on. That would be my recommendation here as to the next step. Actually, quite a bit of information, a lot of historical information. And we'd like the opportunity to summarize it all now that we've heard the arguments from everybody, to see if this is one that goes to the next step. That's my suggestion.
Is there a motion from the subcommittee based on that recommendation?
Does that make a motion that we rely on our legal advisors to review and prepare a report to provide back to the subcommittee to base the decision on?
Second.
Motion been made and seconded, made by Ms. Reynolds, seconded by Mr. Gagnon. Any discussion? Hearing none, I will poll the subcommittee. Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
I too, Raymond Coyer, vote aye.
Gentlemen, thank you.
Thank you.
Very good presentations and very interesting documents have been submitted. Thank you.
We doing this? All right. Next on the agenda, the new business request from public to open files for review for CRMC Public Rights of Way. Request that CRMC designate Noyes Neck Road, Westerly, Rhode Island as a CRMC Public Right of Way. We doing these individually or is it?
So I could do it both together. I'll explain. It's new business, so
All right.
I catch them all together too.
And a request that CRMC designate Breach Drive in Westerly, Rhode Island as CRMC Public Right of Way, and a request that CRMC designate Atlantic Avenue, Westerly, Rhode Island as CRMC Public Right of Way. Director Will.
We received a request that the subcommittee could take up these matters that are on your agenda. And so we put it down as new business only for the discussion of whether the subcommittee would want to put it in its queue, if you will, of matters to be researched as to their possibility to become public rights voice. Not to discuss them, but to accept the request to put it in their queue at a later date.
What's your recommendation?
Yeah, I would recommend, staff would recommend that, yes, the subcommittee take them up at a time in the future, but put it in its queue of potential sites to be researched.
We need that.
I should add that, yes, I should add that I reviewed the documents submitted, so there's a kind of a head start here. And I recommend that you accept them too, so that we can fully review and make a report on these matters also.
Any questions from the subcommittee for Director Willis or Attorney DeSisto?
You have the proponent here and you also have a Ms. O'Toole from the solicitors, the Westerly solicitor, if you want to hear from it, either one.
Does the subcommittee desire? Or do we have to let them speak, or we can go by what's before us, the recommendation?
To me, you've got enough to make a decision. But I just want to note that you do have the proponent present and you also have Ms. O'Toole here also.
What's the subcommittee's desire? I mean, we've got a recommendation and from Director Willis as well as Attorney DeSisto. Are they both? Do we anticipate proponents or objectors?
Oh, no, I just want to note
Yeah.
that they're here.
Yeah.
They're not jumping up. And I think that a lot has been submitted and it warrants further investigation so that the committee take it up.
Okay,
I feel comfortable with accepting the staff recommendation and making a motion that we put these in the queue for further and future investigation.
is there a second?
Second.
Motion was made by Ms. Reynolds, seconded by Mr. Gagnon. Any discussion? Hearing none, I'll pull the subcommittee. Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
I do, Raymond McCoy, vote aye. Anything else to come before the subcommittee?
That is all, Mr. Chair. Just a note that the subcommittee agenda had a Spring Avenue extension matter that was mistakenly added. We had forgotten, quite frankly, I had forgotten that Ms. Boots from the Attorney General was court excused for today. So that should not have been on the agenda.
Okay. With that, I entertain a motion to adjourn. Motion made and seconded. Any discussion? Hearing none, all in favor, say aye.
Aye.
Aye. Anyone opposed? Motion carries. The Rights of Way Subcommittee is adjourned. Thank you all. I'm gonna stop.